Can public officials legally pay for their criminal defense with campaign money? That's a question of interest to several current and former Illinois office holders, and one before the state's high court right now. Amanda Vinicky joins us with more. Amanda.
Yes, Paris, there's a reason that Chicago and Illinois have developed notorious reputations for corruption, and that is because, as you've noted, more frequent than not, we've got a lot of officials who are accused of bribery, attempted extortion, and other forms of corruption. And when they do, they're frequently not paying their legal bills out of their own pockets. Instead, they use their campaign cash, contributions given to them by supporters over the years to pay their attorneys. Now, the question before the state's high court, is that legal? The question is getting raised by Chicago's 25th Ward alderperson, Byron Sigcho Lopez, who took legal action against his predecessor in that office, disgraced former alderman Danny Solis. Solis had relied on his campaign fund to pay legal bills over $200,000, by the way, in connection with a bribe that eventually snared alderman Ed Burke. Now, Burke has since spent about $2 million of campaign money on his legal defense. Burke's wife, Supreme Court Justice Ann Burke, has recused herself from the case now before the state's high court. These are all complicated connections, to be sure, but Sigcho Lopez's attorney says that the matter at hand before justice is really one of common sense. He says that campaign finance laws are meant to prevent and to root out corruption, and it would be antithetical for a law intended for that cause can then be relied upon by corrupt politicians for their defense.
The purpose behind those are to combat and deter public corruption. So what a slap in the face if you have a law that is meant to deter public corruption through campaign limits and transparency and limiting use of money for campaign-related matters, but then you niche out the ability for one of these politicians facing public corruption, the very evil this is supposed to combat, and you allow them to use this money.
Candidates and officials can use supporters' donations, he says, for legal expenses for things like making sure they're in compliance with campaign finance law or for ballot changes. But he argues that Solis's use in this case wasn't business. Rather, it was personal. And he says that should not be tolerated. But Michael Dorf, who's representing Solis's 25th Ward organization, says Solis wouldn't have been in these circumstances were it not for the public position he held. And Dorf says that Sigcho Lopez is acting as if all politicians accused of corruption are guilty. But he says even those that aren't can also incur oppressive legal bills.
People who are public officials who have no connection with a person who may be under investigation may have had an email from that person, and suddenly they are the subject of a subpoena for thousands of records.
Director of Reform for Illinois, Elisa Kaplan, says it can be stomach-churning for people when they think about officials and candidates they entrusted with money and donated to for their campaigns or to run their offices to then use it to defend corruption charges. But she says, again, echoing Dorf, that these are often circumstances that these individuals would not be in were it not for the positions that they hold. And she also says if the campaign doesn't pay for these legal expenses, who does? She says that could put candidates and members of their staff who are not personally wealthy at a disadvantage.
It's understandable why people would recoil at that idea. But think about the fact that, for example, not everybody who's accused of corruption is guilty, and they have a right to a defense, and they would not have had these accusations leveled at them if they were not a candidate or a public official. And so it really is a legitimate, you could see it as a legitimate campaign expense.
She says that it is a complicated question and adds that you also at least have transparency if this is listed as a campaign donation versus potentially having candidates go out and ask, for example, for a GoFundMe to help to deal with any sort of legal battles that they might face. Now, you did have several justices during today's oral arguments interject, including Justice Michael Burke. He is no relation to either the alderman or or to the Supreme Court Chief Justice. Burke, in this case, pointed to an opinion from the New York Supreme Court that ruled that politicians cannot use their campaign funds to defend themselves on corruption charges.
We have yet to reach the point when it can be said that defending against federal or state criminal indictment alleging corrupt practices is an ordinary expense of holding public office. Are we at that point in Illinois where we're going to say that that's an ordinary expense of holding public office?
He did not pose that question rhetorically, but it is perhaps a good way to wrap up this discussion for now, Paris. Couple of ads, though. Justice Burke is one of the individuals who will be up for election himself this year. Meanwhile, you have two measures. One was introduced by a Democratic member of the Illinois House, the other by a Republican, both put forth in 2021 to explicitly forbid campaign money from being used for criminal defense. But both of those measures were held up in the General Assembly, not advancing at all. So with that, back to you.
Amanda, as you know, the fourth quarter campaign reports come out in recent days, and you look at some of those reports, and in the expenditures, you see law firms in many of those reports. So obviously a case of being closely watched here in Illinois. Thanks very much.
Very relevant discussion, certainly.
Absolutely.